This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rarely remembered as the great founder and defender of our Constitution. Our resolution tonight is, should America strengthen social media regulations? From Section 230 to antitrust issues to censorship concerns, some might call this a trending topic. With that, please like, rate, subscribe, and help our chapter go viral. Tonight, we are proud to host Missouri Solicitor General Josh Devine and Dr. John Samples of the Cato Institute to debate this critical question. Moreover, we are thrilled to welcome DC's own Judge Trevor McFadden as our esteemed moderator. We are deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster debate series a reality. I now recognize Ian Stapleton to introduce these three stellar panelists. Please give them a warm welcome.
The Honorable Trevor N. McFadden serves as a judge on the United States District Court for the District of Columbia. Judge McFadden previously worked at the U.S. Department of Justice, where he served as counsel to the Deputy Attorney General and as Assistant U.S. Attorney in the District of Columbia. Judge McFadden subsequently became a partner at Baker and McKenzie here in D.C. before returning to the DOJ, where he was Deputy Assistant Attorney General and acted as the second in command of the department's criminal division. He received his BA in 2001 from Wheaton College, magna cum laude, and in 2006, he received his JD from the University of Virginia School of Law. Following graduation from law school, Judge McFadden clerked for Judge Steve Colleton of the U.S. Court of Appeals for the Eighth Circuit. Josh Devine is the Solicitor General of the state of Missouri. In this position, he works under the Missouri Attorney General and oversees the offices of appellate and special litigation divisions. Before serving as Solicitor General, Mr. Devine was Chief Counsel to U.S. Senator Josh Hawley of Missouri, where he oversaw all legal issues, managed matters related to the Judiciary Committee, and developed technology policy. His recent legal scholarship has appeared in the likes of the Virginia Law Review and the Hastings Law Journal. Mr. Devine received a JD from Yale Law School, where he was an editor of the Yale Law Journal, and a Bachelor of Science in Mathematics, summa cum laude, from the University of Northern Colorado. Following law school, he clerked on the Supreme Court for Justice Clarence Thomas and on the 11th Circuit for Judge William Pryor. Last but not least, we have John Samples, who is a vice president at the Cato Institute. He founded and directs Cato's Center for Representative Government, which studies the First Amendment, government institutional failure, and public opinion. Mr. Samples serves on Meta's Oversight Board, which provides final and binding decisions on whether specific content should be allowed or removed from Facebook and Instagram. He previously wrote The Struggle to Limit Government, A Modern Political History and the Fallacy of Campaign Finance Reform, and he has also co-edited The Marketplace of Democracy, Electoral Competition, and American Politics. Prior to joining Cato, Mr. Samples served 8 years as director of Georgetown University Press, and before that as vice president of the 20th Century Fund. He received his PhD in political science from Rutgers University. Without further ado, I introduce Judge McFadden to get us started with this interesting topic, and we can give our speakers one more round of applause.
Thank you, Ian. Thanks, Brady, and thanks to you all. It's a treat to be with you this evening. I'm really also appreciate all those who are joining us online. I just hope we don't get canceled or deplatformed in the midst of our talk. I know that you've been promised a expert debate on social media regulation tonight. At least for me, though, while I'm very confident that my colleagues here have done a great deal of thinking on the legal issues at stake, I think we're all a little intimidated to be talking about social media to Gen Z students. So we'll defer to you all on how to actually use TikTok, Instagram, the artist formerly known as Twitter, and their progeny in real life. Maybe we can have some Facebook reels later. It'll be great. But I hope you'll have some enlightening questions for us during the audience participation time later in this evening, and really welcome your thoughts as well. Before I turn over to the panelists, though, I'd like to briefly set the table with some background on a couple of the key Supreme Court cases that you'll be hearing about tonight. and also a high-profile statute that looms over tonight's topic. First and most importantly, I'll talk about Moody versus Net Choice. In that case, the Fifth and 11th Circuits had dueling opinions on the central issue today, that is, whether states can regulate social media companies' content, and whether that, and if so, how can they regulate it? The circuits dealt with very similar laws from Florida and Texas that prevented large social media companies from censoring users based on viewpoint. Both of these cases were decided in a preliminary posture. The 11th Circuit, covering Florida, held that states could not regulate social media companies' content moderation without offending the First Amendment. Central to that holding was the idea that social media companies are acting expressively when they decide what posts to remove or retain. In contrast, the Fifth Circuit, considering Texas's law, decided that content moderation isn't speech, so the First Amendment wasn't implicated. The court described the platform's claim as, quote, a corporation's unenumerated right to muzzle speech. You may be shocked to hear they did not think that was entitled to any constitutional protections. Texas had said that it wanted to better balance the marketplace of ideas, and that passed muster for the Fifth Circuit. The Supreme Court effectively said to both courts they'd missed something important. The Supreme Court faulted the circuits for deciding the case as if it was an as-applied challenge to Facebook and Google rather than a facial challenge. For U1Ls, as-applied challenges decide whether a law applied to certain entities is constitutional. Facial challenges decide whether a law is unconstitutional on its face or as applied to all entities that it covers. Net Choice had brought a facial challenge, but both circuits had thought about the challenge as an as-applied one. The court believed that distinction mattered. As-applied challenges just think about whether applying the Florida and Texas laws to Facebook is constitutional. They don't think about whether the laws are constitutional overall. And under these laws could theoretically apply in tons of situations like Uber, Etsy, Venmo, and other services. So the record wasn't well developed, and the briefing didn't explore important factual questions about these other apps. Different legal standards apply for facial challenges, especially First Amendment ones. The court said that the circuit should have considered whether a substantial number of the law's applications are unconstitutional, judged in relation to the statute's plainly legitimate speech. Neither circuit had done this. As an aside, the Supreme Court was unanimous on this point and on the final disposition here, even though it was essentially disagreeing with all four lower courts to consider the issue, that is, both the circuits and their district courts, and on a theory not really argued by any party in front of them. But instead of just vacating and remanding, the court also gave the lower court some pointers, arguably dicta, on how to think about the First Amendment. Three principles are particularly worth noting here. First, the First Amendment prevents the government from telling an entity to accommodate messages that it would prefer to exclude. And that is true whether the messages come from third parties or not. Second, none of that changes because a compiler includes most items and excludes just a few. That is just moderating a very few number of content. It's enough to exclude a handful of disfavored messages for the First Amendment still to apply. Third, the government cannot regulate expressive activity by asserting an interest in improving the marketplace of ideas. States could enforce competition laws to ensure access to communication, but they can't force private speakers to present views against their wishes. Finally, the court took a position on two items in the Fifth Circuit case. First, it stated the Fifth Circuit was incorrect in saying that the Texas restrictions on content moderation do not interfere with expression. And the court also concluded that the Texas government's justification didn't pass even intermediate scrutiny under the First Amendment. the Texas justification was directly related to suppressing free expression because it balanced the marketplace of expressive ideas. Three justices took the position that the lower court should address a common carrier theory on remand. That theory looks at historical precedent for the idea that states can prevent companies that provide common public goods like roadside inns or teletype from invidious discrimination. The Fifth Circuit had discussed this idea, concluding that it allowed states to regulate social media companies because they own a modern common public good. The majority did not address that theory. The second case I wanted to mention is Murphy versus Missouri. In that case, 2 states and 5 social media users sued dozens of executive branch officials and agencies after the pandemic. I should note that Josh Devine is counsel of record for Missouri. The plaintiffs allege that the federal government pressured social media platforms to suppress user content related to COVID and the 2020 elections. They argue that this coercion turned the social media companies' content removal into state action so that it violated their First Amendment rights. The court held that the states and social media users lacked standing, that is, they didn't show any actual injuries like being deplatformed or deprioritized on feeds could actually be linked back to actions taken by federal officials. The states had their own theories, but the court didn't buy them. They argued that the states had a right to listen under the First Amendment to other speakers on social media. But the court said that it only accepted that theory when the listener had concrete, specific connection to the speaker. The states also claimed that they had a sovereign interest in hearing from citizens, but the court said they did not identify any specific speakers or topics that they were unable to hear. Finally, Murphy did not allow the states to claim third-party standing on behalf of all of their citizens who have faced social media restrictions. Reading these 2 cases together, Net Choice decided whether states can force social media companies not to moderate content. Murphy decided whether the federal government can force social media companies to moderate content. I won't express any opinion on these cases, but I'll leave that to my colleagues here. Finally, before I turn over the floor, I want to give a quick overview of an important background statute, sometimes referred to as the Declaration of Independence of Cyberspace. Section 230 of the 1996 Communications Decency Act says that we can't treat a social media company that hosts other users' content as the publisher or speaker of that content, and therefore liable. So while historically one could sue a newspaper for slander, Section 230 ensures that one cannot do that to Facebook or third parties' posts on the site. At least that's how it's been commonly understood. In short, it has generally been interpreted as a sweeping assertion of immunity for social media platforms in a variety of suits, targeting them for harms done by content posted on their sites. So with that overview, I'll turn the floor over to the panelists. I'll ask Josh if he'd start us off.
Well, thank you for that, Judge. When you name a debate series after Daniel Webster, it's a little intimidating, right? I mean, that's not something I can really live up to. Really intimidating. And so when the judge told me how intimidated he was by this, I said, well, I'll come and I'll just set the bar really low. Yeah.
I appreciate it.
There we go. Just kidding. Just kidding on the judge part, but I will set the bar low. So big tech is kind of having the same kind of moment these days that big tobacco had in the 90s, which almost nobody on that side of the table is old enough to remember. But what I mean by this is that everybody recognizes that it's kind of really bad for us, but it's all over the place, and we don't really know what to do about it. And so there's antitrust issues, there's consumer protection issues, there's what kind of effect are these platforms having on children and their mental health, especially girls, and we don't have nearly enough time to get into all these issues. So I'm going to get into the issue of what the judge was talking about just now, the censorship issue. This is the issue that was salient enough, prominent enough to capture the attention of the legislatures of Texas and Florida. And so that's what I'm going to discuss right now. And I want to just briefly kind of give everybody a picture of why we should really care about this and why we should in fact be supportive of tech regulation. So think back to almost 5 years ago now, April 2020, we're at the height of COVID. Let's say you're on the phone with your mother, because of course, by law, you can't actually see her anymore. This is April 2020. And you say, Mom, I think this COVID thing may have sprung from a lab in China. That seems like a plausible theory to me. And suddenly you find yourself no longer on the phone with your mother. Now you're speaking with a Verizon wireless representative who tells you, you have violated the terms of service of Verizon Wireless because you are spreading misinformation. That is not acceptable. And so we are going to kick you off of our platform, the Verizon Wireless Network, essentially banning you from your phone for the next, 6 weeks. Maybe we'll extend it, maybe we won't. Naturally, you're pretty upset about this. So you contact your representative, you contact your senator, and they say, well, Verizon is a private company. They can kind of do whatever they want. And if you don't like it, you can build your own nationwide cell network. Now, let's say a month from now, you are dutifully studying for final exams. And a cold front hits, like it sometimes does in this area of the country. And you see all your friends, the ones with the electric cars, and their batteries aren't really doing well. And some of them are getting stranded, like happened back in 2022 when I-95 was closed for like 26 hours. And so you post on X or Facebook or Instagram, yeah, I don't think I'm going to be buying an electric car because they're just not reliable in the cold. And now your electric company sees this and they call you. And they say, we're a socially conscious company. We take climate change very, very seriously, and we are not going to let you use our electricity to spread messages that we disagree with. So no more electricity for you. Now, I think 99% of people would find these two situations that I've described to be completely intolerable. Maybe Ayn Rand would say otherwise, but pretty much everybody else in America would say this is not okay. And so the question becomes, does it make a difference if it's Facebook, Google, or Amazon doing this instead of the telephone company or the electric company? And I think the very fact that we're asking this question kind of tends to show that we have lost sight of the exact purpose, the very reason that we have government in the first place. I don't think this would have been a very controversial question to the founders. And here's why I don't think that. It's because the founders had a very clear vision of what government is for. And that vision was that the whole entire purpose of government is to stop the private abridgment of rights. The private abridgment of rights. So think of the Declaration of Independence. We have that very lofty phrase that everybody remembers, that all men are created equal. You have certain inalienable rights, life, liberty, pursuit of happiness. But there's a really critical sentence that comes immediately after that to secure these rights, governments are instituted among men. So here we have Jefferson kind of hypothesizing this state of nature before government. And he's saying the whole reason that we have to create this government in the first place is because private individuals are abridging other private individuals' rights. We need a government to stop this. And Madison agrees. He says in Federalist 51, if men were angels, no government would be necessary. This is the whole reason we have government. And when we get out of the realm of free speech, when we talk about anything else, this is pretty intuitive to people. This is exactly what criminal law is. The whole apparatus of criminal law is the government stopping private individuals from abridging other people's private rights. And what I'm saying today is that it's no different with speech. Speech is one of those natural rights that pre-exists government. Our right to free speech does not come from the Constitution. It is protected by the Constitution, but it pre-exists the Constitution. And so if that's true, then just like a private company can abridge any of your other rights, so too it can abridge your free speech rights. And I think it's also important to remember that when we talk about something like Facebook or Google, or when we talk about these issues in general, a lot of these issues are downstream from a lot of governmental decisions. Facebook does not exist in the state of nature. There is no such thing as a natural corporation like Facebook. Facebook is this artifice that has been created through Delaware corporate law. I mean, if you look historically at what corporations used to be, the kind of corporation that Facebook is was not permitted at the founding. Corporations were very limited. You could only get them for a public purpose. They had to be state chartered, these sorts of things. And there are all kinds of policy arguments for why that was a bad kind of system. My point, though, is that was a system that we had. Government decided we're going to actually create these artificial things called corporations. We're going to give them limited liability that doesn't exist in nature. We're going to make them perpetuate forever that doesn't exist in nature. And then so we get this kind of weird situation where we have these amorphous corporations that are created by the government or created at least through laws passed by the government. And now we're saying that this thing with hundreds of millions of shareholders now has free speech rights. And is actually able to take down and defeat somebody else's speaking on that platform. And so I think we end up in this really strange situation if we're number one, not remembering what government is for in the first place. And number two, not remembering where these corporations come from. Now, I've been a member of FedSoc since my 1L year. I'm a conservative individual. I lean libertarian on a lot of different issues. I like it when the free market can decide things, can pick winners and losers, can fix our problems. So why isn't the free market the solution here? Well, again, I've already described how Facebook is kind of an artifice of a lot of different government decisions. So it's not like this it's not like this pure free market that is sometimes idealized. But number two, we're dealing with a hyper-concentrated environment. The entire social media apparatus is controlled by essentially four people. You've got Mark Zuckerberg at Facebook, two people at Google, and then Elon Musk at Twitter/X. And what you find is that the most valuable thing about these different companies is not their user interface, it's not even their content moderation policies, it's their network size. Facebook has 3 billion people on it. That's a lot. That's nearly everybody who has an internet connection in the world. That is an enormous barrier to entry. And yes, there are things like Parler and Mastodon and all kinds of other things that most people have never heard of, but it's not a fair comparison to say, well, you can switch from Facebook to Parler. That's a lot like saying that, it's not like saying switch from Uber to Lyft. It's more like saying switch from Uber to walking. And so you have these massive networks from these companies, and there's a reason, for example, that Google had $75 billion in profits, not net revenue, but profits in 2022. This is not a competitive industry. If it were a competitive industry, lots of people would be hopping in trying to get a taste of that $75 billion profits. And so this is one of those sort of classic examples that you have in economic policy, where you need some kind of intervention, because this is not an area where the free market is really going to be able to solve these problems. There's an event happening in 6 days from now. I don't know if anybody's been following that, but 4 years ago, almost to the day, there was another very sort of explosive event that happened, which is the New York Post decided they were going to run this article. Had some pretty, politically damaging information in there about one of the candidates' sons, who turns out all this information was true. And Facebook and Twitter and Google, they decided, well, we're actually just not going to let you read about this. This is misinformation, even though we're going to find out later it's true. And we're just not going to let you read about this. Well, about a year before that, there is a memo that was written from one executive to another at Facebook. We only know this because this memo was later leaked, where this Facebook executive said, wow, we're going into a presidential election year. I just want to remind you all that we, Facebook, have the power to alter the course of this election and to effectively pick the winner. Now, we're not going to exercise that, and he goes on and on and on about why it would be a bad thing to do this thing. He likens it to the One Ring. I think most people in the room are probably too young for that reference, also. But says, hey, we're not going to exercise this power. But of course, then we see them suppress the Hunter Biden laptop story. We see a number of other instances over the course of that year. And so I think I'm very worried about government power. I have something like 60 lawsuits against the federal government right now. But if you're worried about government power, then you ought to be worried about companies that are powerful enough to shut down your business, companies that are powerful enough to shut down legitimate debates, and companies that are powerful enough, or at least think they're powerful enough, to actually pick where government is. I'll go ahead and turn that over.
Thank you very much. So, Ayn Rand, she always shows up. However, and I'm not much of a mood to defend her because she had certain other problems. But she's not a nice person. Down the state, there are people that don't like her. I would point out to you that she was a response to a certain period in the United States. The New Deal and after, in which, and F.A. Hayek was another, the road to serfdom. He seemed very much to be on the road to serfdom. So I'm surprised to hear at a Federalist Society conversation that the New Deal theory of business is so recently discussed by and adopted by Cass Sunstein. That is, that government creates these businesses, is now given forth as an idea of regulation. Seems to me that the purpose of government is pretty clear, particularly in this free speech area, unless you want to argue that has nothing to do with freedom of speech. Because all you have to do is, whether you're a originalist or not, is look at the Constitution, and it says Congress shall make no law abridging the freedom of speech or of the press. It does not say Congress and Facebook, or Congress and a business corporation and so on shall do so. The other issue about corporations themselves, right, is I remember now getting for 14 years ago, in the case of Citizens United, there was discussed by a majority of the court that was essentially eviscerating the campaign finance system, that corporations as entities had rights, including freedom of speech rights, for about 150 years at that. So that is why the entire logic of Citizens United came about. So this is not anything new. You can pull it back at this point if you want, but you're also going to get rid of a number of protections for a number of organized interests. So it seems to me that the problem of government, what government is for, is to do certain things, but it also is a fearful master, and that's why we have a First Amendment. So then the question becomes, there's another issue here that I want to briefly, and is rarely noted in these discussions, which is, what is the purpose of Facebook? Why do we have corporations? Why do we have business corporations, firms? And the answer is their purpose is to maximize shareholder value, correct? So when you talk about muzzling speech, you can say, well, it's likely that they're doing it for political reasons, but I think it's more likely that the most legitimate reason is they have to muzzle speech to serve their primary purpose, which is to maximize shareholder value. And if you doubt that, and I don't know, this is always a problem, since you can see I'm an old guy, I'm older than these two guys, I think. And no, I don't know.
He's talking about me, unless you're talking.
No, I'm aware of that. I'm definitely older. So I really don't know how much you remember about the history of the internet, but there have been really pure First Amendment that go as strong, and sometimes probably go over into incitement too. Sites like 8chan, 4chan, believe me, these were not profit-making undertakings. And it is also true, and there is a slight kind of strangeness that we could talk about, I guess. But in fact, it doesn't appear to me that X.com is maximizing shareholder value, because it is a First Amendment thing. And why, you can ask, why is that so? And the answer is because to maximize shareholder value, you have to have as many people on the platform as possible. There's some margins, but there's some people you don't want on the platform. And those are people that drive everyone else off the platform, that you're trying to link this two-sided instrument. You're trying to link people who are on the platform to advertisers. If you drive people off because heads are rolling through or people are doing things, Nazis and so on, and various kinds of things, then you're not serving shareholder interests. Now, it is true if you're thinking shareholder interest is not, despite the accusation of Ayn Rand, shareholder interest is not an absolute. That's true, right? But it is a primary obligation. Then you have to have reasons to countermand it, right? You have to have that's reasons for regulation. But there's some areas of regulation that are some areas that are outside of regulation, even if you have third-party effects and so on. And one of those, I think, would include, and that's what comes out of Net Choice versus Paxton. While the issue of common carrier as a justification for regulation is not directly undertaken or confronted in that case, it does seem to me that the recognition that content moderation has expressive values that are protected by the First Amendment is very strongly stated in that case by a majority of the justices. So if in fact, so in a sense, the common carrier case is gone, even though through the silence of not discussing it, but because the affirmation of curation as a First Amendment right is so strong that that particular justification for regulation is gone. And you can see why if you read Facebook's charter for the thing I said on the oversight board. It sets out a series of values for the corporation, free speech being paramount, and also values that contravene that. That is, in some cases, can outweigh free speech. There's about 4 of them. But all of these are values that are related to expression, they're political values, and they're chosen by the corporation. So it's easy to understand why they're protected under the First Amendment. So I think the case for regulating content moderation is going to have a hard time in the courts. I would say we do have, in Facebook's case, or Meta's case at least, there's been undertaken an alternative, which is the thing I work on. Oh, before I do that, let me talk about the antitrust problems, right? The problem of entry is really the antitrust problem. You don't have an alternative. It just so happens that today is October 30th. So on Friday, 2 years ago, today, the Meta closed at just under $600 a share. 2 years ago, on November 1st, probably about midday, Meta had a share value of $80. It closed that day at $117. And it had been in the $300 or $400 range throughout most of the late teens. Now, how do we explain an $80 share valuation 2 years ago and a $600 one today? There's this thing called TikTok. TikTok had entered the American market and had essentially found a better algorithm or a more popular algorithm to allocate and to be the basis of the social media. It was a different model of social media, but throughout 2022, it created severe problems for one of the largest corporations in the world. Now, that led, and this is an element of this that's not strictly legal, but it led to changes at Facebook. Basically, I would say one thing that happened was everyone got fired. 17,000 people were fired. Mark Zuckerberg said we're going to become a tech company again. And so you're all lawyers, so it doesn't matter. All the humanities VAs got fired. So it's a business again, right? That's part of it. The other problem you may have noticed, and at various places, government plays a role here. You may have noticed that TikTok, the government threatened to shut down TikTok or to sell it to who knows, right? that is still up in the air, but is essentially the net present value of TikTok has been profoundly affected by government actions. So my point being about the $80 is there was entry, there was a near failure, there was definite panic at Facebook. And so I think there is the antitrust case is much weaker than you would think. The other thing is there's other issues that would be connected to have it to breaking them up. I would say just to finish now, I'm probably out of time. The real issue here is not Facebook. The real threat to American rights, the freedom of speech, is the European Union. They passed a law in last year called the Digital Services Act that has very vague language about systemic harms. The companies are supposed to negotiate what those are with organized interests called NGOs. And if you hear the word NGOs or you hear the word stakeholder, run, or in your case, prepare a lawsuit. And essentially, the problem is Facebook has to follow the Digital Service Act or faces fines of up to $8 billion a year, 8 billion with a B, which even Mark Zuckerberg notices. I don't know about Elon, maybe not Elon. But you did see Elon got into a fight with the Brazilian authorities and ultimately had to back down. The problem is Facebook has a preference for single rules for the platform, which you can imagine why they would have for business reasons. So it very well might be that we all end up living online by European rules. Now, I think forcing Facebook for reasons of viewpoint discrimination to have more than one rule would also be problematic under First Amendment. So that's why I suggest that this is actually a foreign policy problem. The government can do something, but it has to do something to the European Union and the European Commission. And let's face it, ladies and gentlemen, what greater pleasure there could there be than doing something to the European Union and the European Commission?
Well, thank you, John. I want to give the panelists a quick opportunity to respond to one another. And Josh, in your response, it sounds to me like you two might clash most fundamentally over a differing views of corporations. And what I'm hearing from you is more of kind of a founding era view of corporations serving the public good, being given very limited charters. And I think John is describing a view that's been more prevalent in the last 100 years or so, corporations existing to promote shareholder value and having a much more commercial lens. I wonder, would your view undermine Citizens United? Are you willing to say corporations have no First Amendment rights? They can't donate to parties, or at least only can through subject to government regulation. What's your view?
So I'm not taking that view. My point in bringing up sort of the history of corporations more generally is just to emphasize that this isn't how it has to be. We've made as a country a lot of public policy decisions to create these artificial entities in the way that they exist right now, and we don't have to do that. There are a lot of different variations on things we can do. Now, I think that the best reason to have a corporation is because there are certain things you just can't do unless you collect a lot of people and pool their capital together. Bridges in the older days, railroads, and I mean, you think of these mining companies that have these tractors where just the tires are like 15 feet high, right? Like no individual person can afford that, right? And so there's a very useful order for corporations in modern society. What I would say though is that there are major differences between different kinds of corporations and between different organizations. In the Citizens United circumstance, you had a relatively small group of people coming together and saying, we want to make a video that is critical of one of the presidential candidates. And that's like pretty much core speech, right? And core speech doesn't become non-core speech just because 10 or 20 or even 100 people are doing that. So I think John and I would agree on that. It becomes a little strange though when you have, this corporation with hundreds of thousands or millions of shareholders, and there's terabytes of data being uploaded to this thing every day. It becomes a little weird to say, yeah, this is Facebook's expressive activity when everything that you see on the newsfeed, like that just doesn't even make sense. Especially when you have AI algorithms and things like that are going into this. I mean, Justice Barrett recognizes this in her concurrence. She said, maybe things are a little different if you have AI involved in this, because it's hard to even call that expressive. And so that's a major point that I want to highlight when I talk about the history of some of these corporations. Is all of these are public policy decisions that we've made, and we're living with the consequences right now. And if we don't like those consequences, there are actually a lot of things that we can do. Doctrinally, there are some difficult things. Texas and Florida ran into that. If you go more into the antitrust sphere, you're going to run into fewer of those doctrinal issues. I also wanted to push back on this idea of corporations maximizing shareholder value. Yes, that is what we are taught in business organizations, is that corporations are supposed to do, but there's not a single person in this room that does that. There's not a single person in this room who's like, I'm just going to maximize the amount of money I'm going to make. I'm never going to take a vacation. I'm never going to buy anything. I'm just going to maximize the amount of money I'm going to make. And there's no person in a corporation who does that either, right? When Coca-Cola rolls out blatantly illegal DEI protocols, where they're saying we're going to have racial quotas for the types of people who are working on projects. And these aren't things that were even arguable before the Harvard affirmative action case. These are things that have been very clearly illegal for 50 years, right? That's not something that Coca-Cola is doing to maximize shareholder value. That's something that Coca-Cola is doing to virtue signal and to pursue certain ideological ends. And that is what every corporation is doing. And so, I do think there's something to this idea that, some of these companies are going to have to moderate content in order to be a profitable company, et cetera. But I think, let's be real, what a lot of these companies are doing is going much beyond what they have to do to remain profitable. They're interjecting themselves for political reasons, for ideological reasons, for personal reasons, for whatever reasons, many of which are just completely illegitimate.
John, love to get you to respond to that, and specifically, I mean, your description of corporations existing to maximize shareholder value. That's kind of a classical view of corporations. As Josh suggests, that's been eroded somewhat, including the Business Roundtable within the last few years, I believe, has suggested that, well, maybe we should be doing other things, including, helping the environment. And so does that, is there no longer a kind of an agreement about what corporations exist for? And the other thing that occurred to me as you were just kind of inviting us to bash the European Union, which is,
I'm going to invite you again in a minute.
There's unanimous agreement here. Well, I won't speak for the judge, but John and I agree.
But I think one of the concerns there is, as you suggest, who better to bash the European Union than the United States government? And if Facebook needs the United States government to bash the European Union and or other foreign competitors, doesn't that get to a bit of the murky concern about corporations really depending on the federal government and being their actors?
Yeah, that's true. Well, let me first return to the stakeholder and alternative theories, and with the sainted memory of Milton Friedman in my mind. It's the Business Roundtable. There's other people. These people meet at Davos, and they're called the World Economic Forum, and they are, let's put it mildly, not capitalist, right? I just think that's a bad theory of how to run. And also, I have other people who think that. It's called modern finance theory. The people who model what people do in financial markets also think the net present value of the firm is what people are focusing on when making investments and buying and selling these corporations. So it's reality how these things actually work in terms of capital investments, investments in these corporations. Now, whether in every case everybody thinks about that at every moment, I don't know. I was told that they have said, I mean, that's one of the problems I think that irritates Zuckerberg is too much politics. Because stakeholder is going to be, really what you're saying is highly organized interest. The hated interest groups don't control the government, they control the damn business. That's what you're really arguing for. And that's what Europe's got. And what else does Europe have? No growth in 20 years. No growth in 20 years. They're so far behind us on the productivity. Read The Economist last week. Read what those economies look like. It's real, folks. Now, the other question was, I'm obviously very anti-European. I didn't start out like that.
Yeah, Facebook relying on the
Yeah.
United States government
It
to do
is.
that fashion.
It is, well, and also I think,
Or protect them, I mean, more positively, right?
well, to create some space for them to pursue, because I don't think, I'm pretty sure that Facebook, I mean, so you have this problem. What if Facebook has to adopt these speech codes in Europe to avoid an $8 billion fine? That makes sense. I mean, that's with Elon and X.com in Brazil, you've got to take these people down that the government doesn't like, right? They don't necessarily want to do that. They don't necessarily think that that's not their decision. The odd thing is what does the US government do when another government coerces an American corporation and the possibility of that American corporation applying those standards to the United States citizens? What do you do? And it seems to me you try to figure out how to make that other entity that is coercing the corporation wish they hadn't. Right, change their behavior. That's diplomacy. I'm not going to start. I don't think we have to use any other threats. Just diplomacy. But there's that. I mean, there is the other argument, though, right? Which I will admit there's some uncertainty about, which is the government could force Meta to have different rules for different countries. But I do think if you did that for reasons of viewpoint, you would run into the same problems from net choice.
I'll just tap in there for just a second. I worked in the Senate for 3 years. I met Mark Zuckerberg, and I'd never met somebody who was as wealthy as he was, right? I thought like maybe you shake their hand and money just falls out of their sleeves. It turns out that's not the case. Well, anyway, one thing I found from meeting with Mark Zuckerberg was really interesting, which is he asked us to regulate them, right? He wasn't the only one. There are a lot of companies that ask the government to regulate. Now sometimes this is cynical. You regulate us, the big guys, and then regulate everybody who's smaller too, and they'll not be able to compete with us. But there is a foreign policy element. There are a lot of tech companies who want to go to China. China wants them to have all their data stored in China. That's a huge security risk. The companies would like to be able to say, sorry, we can't. The silly Congress has passed a law saying we can't do this. And so there is an opportunity here for regulation that is actually very, very pro these businesses and pro consumer also, that I think a lot of people could probably get around.
Josh, so folks, we are quickly coming to the audience participation point of the evening. So if you have a question, be getting it ready and be thinking about how it's going to end with a question mark. I did have before we do that, Josh, we've kind of alluded to common carrier doctrine, something that the Fourth Circuit had suggested as maybe an alternative way to have regulations. And then you've also mentioned antitrust regulations. I mean, frankly, it looks to me after net choice, you're going to have a hard time on some of these more direct regulatory measures. What do you think about using the common carrier doctrine or antitrust?
Yeah, I was a little confused that the Supreme Court doesn't really, in the net choice case, doesn't really discuss the common carrier issue at all. I mentioned earlier Verizon Wireless. Why is it that you don't see this issue with telephones? Well, it's because actually you used to. Now, before telephones, you had telegraphs, which are, kind of like primitive text messages. And those companies were censoring stuff all the time. Judge Oldham in his Fifth Circuit decision goes through this history, censoring stuff all the time. They're doing a lot of what Facebook is doing today, right? And they're taking the position, well, I mean, the First Amendment doctrine wasn't the same back then, but I imagine the company would say the same thing today and we're like, well, we're editorializing, we're content moderating, and we have an expressive right to do so. But Congress and the states passed legislation saying you can't do that. It was upheld, including by the Supreme Court. So you have 150 years of saying these mass communications networks, you can prevent them from censoring stuff. And so for the Supreme Court not to even mention this, almost 200 years of history of this, I thought was very strange. So I don't know if that means what, John was kind of suggesting earlier, that the courts just, we're going to set the marker, we're not going to deal with this argument because it's kind of is running against the doctrine in a way we don't like, and so we're just going to ignore it. Or I don't know if maybe it just wasn't teed up well enough by the parties. But it might be interesting to see if the Fifth Circuit does something similar and says, okay, well, the Supreme Court didn't really overcome this. But I do think you're right that the more things are looking like what Texas did initially, the harder it's going to be doctrinally. And so these antitrust examples, one of the benefits of antitrust is it's speech neutral, it's content and viewpoint neutral. It's one of these sort of like meta regulations. Maybe I shouldn't have used that term. High level regulations that has downstream consequences. And so I think something like that, you're going to very quickly get out of the First Amendment doctrinal difficulties. There are other difficulties that you're going to deal with in the antitrust context, but you're not going to be dealing with the same difficulties that they had in that choice.
John, as you know, this general discussion, especially on conservative side of the aisle about regulating big tech, began several years ago, back when X was Twitter, and there was kind of a perception anyway that big tech was very much on one side of the aisle. Obviously, Elon Musk has changed that equation. Does that, to you, suggest that the marketplace of ideas is working and that we really don't need government regulation? And I guess kind of on a similar thread to the self-regulation, your work on the oversight. Do you see that as a template that other platforms might adopt to self-regulate and get rid of the need for government regulation?
So I'll go into that in a second. I think I was thinking about this for this event, and I think we have to acknowledge there's been a rapid amount of change since. I mean, the starting point of this was Election Day 2016, wasn't it? I mean, let's be honest about this. And a fair number of people lost their minds after that, and you had a lot of things, including, the Hunter Biden laptop, which was mentioned earlier. Have you read, though, about what Mark Zuckerberg has said about that, about the Hunter Biden laptop? He said that an FBI agent said about 2 days before they had to decide about the laptop, they told them that a Russian misinformation effort was coming. We fool around a lot and talk about all these things. That's pretty damn scary to me. An FBI agent said to this guy that runs this giant platform, maybe you want to be on the lookout for something, which makes sense. You can see that. You can see why that might be, et cetera, if you don't have a strong First Amendment view about Russians. But that's why what they did was they didn't take it down. They just disintermediated. You couldn't share it with anyone. So it stayed on the platform. Others took it down. I think we're missing the point about that. There's other things, like you've probably heard of Media Matters here in Washington, D.C. In the spring of 2020, they listed about dozens of things that Donald Trump had done that should be taken down by the companies. classic left-wing group, very concrete suggestions. How many of those do you think got taken down? The answer is none. We don't know everything that's going on and so on, but I think that part is overblown. Now, the oversight board. So I want to talk about a particular case. Those cases, like he's a real judge. I'm sort of one of those, an appointed judge of some sort for.
You're a more highly paid judge.
Oh, you think so? Yeah, I keep hearing about these book contracts, right?
Send me one.
Okay.
Didn't you guys sue to get a cost of living adjustment every single year or something like that? Right?
That's when I was even younger than you are now, Josh.
So we have cases like judges do. So I'm gonna talk about a case it's public, and I may do something I'm not supposed to tell you because yes, there are non-disclosure agreements, 50 pages of it concern my behavior. But here's the case. There is this entity called Libs of TikTok, you may have heard of it, right? And Libs of TikTok, which is on Facebook, about 3 or 4 months ago, published 2 videos. One of which was a transgender woman in a bathroom in North Carolina, the video, and it had some commentary with it about that was about either the policy or about transgenderism in general. It's an important distinction from Meta. The second one was a video of a track meet that was won by a transgender teenage athlete. And the video featured this, spontaneously booing by the audience when they won. So these 2 were on Facebook. And so the question is, Facebook has hate speech laws, rules, which say that there's various things you can't say and can't post about transgenderism. The question is whether these 2 posts violated those rules or not. Now, this is a crucial test, but I don't think it's a crucial test for Meta, because Meta left both of the videos up. They went through a process and decided that they did not violate the rules, which is not something you would expect, listening to the last few years of discussions about social media. The case, however, went to the oversight board, and it will sometime early next year, you will learn of a decision. So I think this is a crucial moment, though, in the history of this institution, because this is a hard case for most of my colleagues. I think it's a hard case for people who have their doubts one way or the other about transgenderism. But it's a hard case precisely, my colleagues who come from around the world, I told them the American thing, which was, I thought it's a liberal, New York Times once wrote a book said, the real test of freedom of speech is that you protect speech that you hate. That's the tough one. And so this will be for some people, I think it was for many Meta employees, it may well have been protecting speech that they hate. We'll see about the board. I will say that it is a matter of fact that this institution has been offered to everybody of any significance in social media, and all have passed on it. Indeed, though, one of the issues is Meta's gone a long way toward being transparent about rules and procedures and so on. And it's not clear that they're in better shape because of that than, say, Google or YouTube or you name your company. All the transparency and everything, I'm not sure. They have to make that assessment in a year or 2 about whether it is. So that's my honest view of this. It's up in the air. I think it's been very good for freedom of speech in other countries, right? With the exception of war zones. But in many countries, it's been very good. I mean, we basically took down the Prime Minister of Cambodia, which you will know maybe as Kampuchea back in the bad old days. He was Khmer Rouge, which I think makes it's really bad, people. But he threatened his political opponent in a speech, and it was removed. So, but it was all Donald Trump was also removed. on January, the afternoon of January 6th.
All right, we're getting near the top of the hour. Any questions for our panelists? Yes, sir.
I was wondering, related to this argument about treating Facebook and Twitter and so on like common carriers, how do you decide who is a common carrier and on the one hand avoid punishing Facebook and Twitter for being big, or do you try and treat Parler and Truth Social like they're also common carriers?
So I think almost inherent in the definition of common carrier is bigness, right? And so, you sometimes get this talking point of, oh no, we're punishing this company for being successful and big. It's like, no, we're not punishing the company for being successful and big. What we're recognizing is that a very large, very successful company is going to be able to bridge people's freedoms in a way that a smaller, much smaller company can't. So I think, do people know who I'm talking about when I talk about Jack Phillips? Jack Phillips is a cake baker in Colorado who has been involved in a lot of litigation because he refused to bake a custom cake for a same-sex couple. I think Jack Phillips, the local baker, I mean, somebody did an analysis one time and they looked at just how many bakers the couple had to pass on their way to drive to Jack Phillips' store, and it was like dozens, right? There's a fair amount of evidence that suggests that this was essentially a politically targeted scheme against Jack Phillips because they didn't like him. Now, Jack Phillips, the single local baker, is very different than Jack Phillips Corporation that runs 10,000 bakeries across the United States. I think it's just a totally different situation if you're a same-sex couple and you can't get anybody to bake you a cake because there's one cake baker in all of America, or maybe 3 cake bakers, and they all have the same views. So yeah, I mean, these common carrier obligations are necessarily going to apply to a big company in a way that's not going to be true of the Parler or Jack Phillips, the local cake baker.
So you have a professor here, I believe, named Randy Barnett. So he has a slightly different version. It's not a common carrier argument. He has an argument about that goes back to the Reconstruction period. Oddly, though, he hasn't developed the argument, and as far as I know. So what I'd like for you to do next time you see him is ask him where the hell's that argument as an alternative to common carrier, because Samples thought, and a lot of other people thought it was a pretty interesting argument, right? Why don't you and ask him what it was, and then he'll tell you, and you'll be interested too.
Right. Yes, sir.
So this question might sound facetious, but it's not meant to be. But if the concern is that, the states are concerned about the moderation policies that the platforms have, why don't the states just create their own social media platforms, right? I mean, like, I don't think there's any constitutional barrier to the state of Missouri creating its own social media platform. And at that point, the First Amendment applies in all its glory. It's unambiguous state action. And so you don't have to worry about market pressures, so the barriers of entry shouldn't really bother you. Why don't you just do that instead of trying to sort of graft these doctrines onto the platforms?
Have you ever seen government do anything terribly well when they're talking about that? I mean, so you offered a question that you said wasn't facetious, and so I obviously gave you a facetious answer. I think John and I agree that we don't. A platform that is pure, that follows the First Amendment rules to the T, it's probably not a very good platform. At least the way it's currently organized. Now, I think one thing you could do is, one of the big problems I see with tech companies today is you have these massive networks, which are very valuable. Facebook's 3 billion person network is extraordinarily valuable. But the problem comes from having the concentrated control over that network. So if you think about email, for example, nobody owns email, right? You can't get kicked off email. Now you might have an email servicer or a specific end user program that decides to kick you off or whatever, but nobody can kick you off email. And so you could have a very, very powerful, very large network like Facebook is, but you could have a situation where there's actually competition in the content moderation. So Facebook has its moderation, its algorithm, and we decide we like these posts and we don't like these other posts. And then you could have somebody else gets onto the Facebook network and says, I don't like that algorithm, I don't like that content moderation. I'm going to pick this other algorithm that has been developed by whatever organization. I think that would look like a much, much better world. And in that kind of world, you can actually have something that looks more like a First Amendment laissez-faire thing, because everybody can choose to get the content moderation tool that they want rather than having everything look like, I don't know, uncensored Reddit or something like that.
Well, Reddit is, I mean, it's not, you don't get everything you want, but it's decentralized. And it was also took forever to go public and to become profitable. It could be that one of the outcomes of AI will be that people will have much more control over so you will have more differences. And frankly, the other thing I would say is my experience with Facebook, which I know it's an old people's thing, but my experience is that you can really control, you take some experimenting, but you can really control what you end up seeing. And in fact, mine is becoming rather banal and boring. Particularly when I go to x.com, I think, good Lord. So you do have a lot of control.
Josh, any closing thoughts for the good of the order here?
You know, I'm kind of fascinated by this. This is going to sound like a tangent. I'm kind of fascinated by the way that we describe revolutions, right? Like you learn in history about the Industrial Revolution. The Industrial Revolution was like 150 years, right? Or you know, we have these revolutions that are a very, very long time where nobody really recognizes that they're living in one. Obviously, you have the French Revolution that's much bloodier and much quicker, but you know,
There's no guillotines.
There's no guillotines. And I am, you know, 70% convinced that when they describe the history of this time, the internet will be the most transformative force during this revolution, and the second most transformative force will be social media. This is really, really affecting culture. It's affecting everything that we do, and we're gonna live with the consequences. So we ought to take social media very, very seriously.
I think it's important to recall that when I was young, you did have, for a variety of reasons, three networks who decided what 70, 80, 90 million people thought was the news, the interpretation of that news, and so on. And now we don't. And believe it or not, the people who did the news in 1968 and 69 were not conservatives. You may find that odd. I think that, and when I read what people on the left say, they are very worried that they've lost control of the narrative. And they lost control of the narrative because of things like Facebook or Twitter or whatever. Right? It's not because of Gab, because it's just too small and too off-putting, right? So yes, there's always problems with every revolution and every change, but it's important to not forget what the world was like and who has benefited perhaps the most from these changes.
Well, ladies and gentlemen, thanks so much for your attention. Please join me in thanking our panel.